Another thing that you should be asking, who are the potential defendants? Are they private attending physicians? Are they residents, doctors in training? Are they nursing staff? Are they employed by the hospital? We always need to know whether they are employees. Why do we need to know that? It's because of two doctrines that each of you know about, called vicarious liability and respondeat superior. We know that an employer is always responsible for the acts of its employees. And we always need to know whether the doctor was an employee of his professional corporation or were they employees of the hospital. We will always need to bring the employer or the professional corporation into the lawsuit as well as the person who actually caused the harm. Okay, so now you know this information. The question I have for you is, what do you do next? What do you do at this point? Now you've garnered all this great information. You've learned the story, you've determined it's timely, you have some ideas about what type of theory it is, you understand that there are some legal issues that need explaining, and now you've got to ask yourself the question, do you want to handle this on your own, or do you decide to refer it out to an experienced medical malpractice attorney? If you choose to send the case out to an experienced attorney, here are a number of things that you must know before you make that phone call. You have to know that the fees in a medical malpractice case is different than in an ordinary negligence case. So in an ordinary negligence case, the attorney's fee is a third. And there are variations about when the expenses get paid. But for the most part, it's a third. In a malpractice case, the fee is less, much less. It only starts at 30% and drops by 5% as we go up in increments in what we can obtain for the client. It's known as a sliding scale. So let's say, for example, we take on a case that's been referred by someone and I'm able to obtain 22% as the attorney's fee. You would then receive 22% of our 22%. If we can get 30%, then it would be 30, you would get 30% of our 30%. So it's a sliding scale of a sliding scale. Before you can justify getting a referral fee, you have to agree to two things. The first is you have to discuss with this person who's a potential client the fact that you are now referring them out to an attorney who handles these cases on a regular basis and get their consent that if they are successful, there is only one attorney fee that will be shared between two law firms or two attorneys. You must get their consent. And that's typically done by the attorney who's handling the case for you. They'll put it in writing in the retainer. The other thing that you must keep in mind is that you must participate in and assume joint responsibility for the case. Now, what does that mean? Well, it means different things to different attorneys, and there's no bright line other than to say what qualifies as doing some level of legal work. Well, some people would argue that doing some level of legal work constitutes talking with the client, identifying the issues, identifying what facts are important. Some would argue that getting the patient's medical records constitutes some level of legal work. Some would argue that talking with the attorney who's taking on the case to discuss legal strategies and the claims that are likely to be brought constitutes some level of legal work. So before you send the case out, you must identify from whatever attorney you're going to use what they ask and what will help you justify receiving a referral fee. As long as those things are met, then you have no problem obtaining a referral fee if they are successful. If the attorney that you send the case to rejects the case, it is very important that the attorney send out a non-acceptance letter. We call them rejection letters. But contained within that letter should also be your name. Hey, Mrs. Jones, I just want to let you know that neither I nor Mr. Referring Attorney will be able to help you with your problem. You have only 2.5 years in which to file a lawsuit. I highly recommend you go to another attorney immediately to get another opinion. So ask the attorney whether they do that. Another thing you want to know is, does the attorney have the ability to communicate with his clients on an ongoing basis? Is it monthly? Is it weekly? How often do they communicate with their clients? You want to know whether they have a system in place. And by the way, if you do not have a system in place to communicate with your clients, I would highly recommend you developing one, because the more you communicate with your clients, the more they recognize you are helping them, working on their case, the less client calls you get saying, hey, what's going on with my case? I haven't heard from you in months. Very important to identify what type of communication system they have. Oh, we don't communicate. We just wait for the clients to call us. No, that's not good enough. Every month, phone call should be going out, or a letter, or an email, whatever. Maybe every 2 weeks, something to communicate on a regular basis, to keep them in the loop, and to keep you in the loop. Very important. You don't want to simply have a year or two go by wondering, what's going on with that case I referred out to that attorney? You need to be kept in the loop. Okay.